Chris Bishop.
Speaker. Mr Speaker, pleasure to take a call on this bill. Always a pleasure, of course, to follow Chris Farfoy, my friend from the parliamentary cricket team. Always a learned contribution, and I think spoke very well. Mr Speaker, I did find it a slightly odd contribution from Mr O'Rourke for New Zealand First, because let's be very clear about what New Zealand First is voting against tonight. New Zealand First Party is voting against putting up the penalties for the supply and the creation and the distribution of objectionable material. I did listen to your speech. You said you are going to vote against this piece of legislation. So let's be very clear. And it's particularly odd that they're voting against, given the words of Mr O'Rourke in the first reading debate on this bill, when he said New Zealand First welcomes the increases in penalties and the new offences that are specified in this bill. Indeed, he also said, it is always a pleasure to support good government legislation. And indeed, he was right a few months ago. And he said New Zealand First will be happy to vote for it. But it's not a good enough argument to say that you're going to vote against a piece of legislation, because it does not go far enough. Now, Mr O'Rourke's colleagues in the Green Party over on the opposition benches often vote in favour of legislation whilst expressing caveats and the belief that they would go further in some instances, or they would change a few things. But on balance, they often say, actually, this is generally a good bill. We might do a few things differently. We might increase the penalties in some particular instances. We might change a few things. But on balance, is this bill going to improve the lives of New Zealanders? Is this bill going to make New Zealand a better place? And the Green Party often votes with caveats. In fact, I think, to be fair to listening to Mr Clendon and Ms Slogie's contribution in the debate tonight, that's exactly what they'll do. But not so for the good people in New Zealand First. No, no, no. If they can't have it all their own way, if the bill is not perfect, they will vote it down. And I say, actually, Mr Speaker, that is very regrettable, because what this bill does is very important. This bill increases the penalties for people who supply and distribute child pornography, and it fills a lacuna in the law in which people can intentionally view material but not necessarily download it, and therefore can't be prosecuted. So that's a very important part of the bill, and New Zealand First is opposed to it, and I think that's regrettable. And I urge you're voting against the bill. So I urge you, sir, to reconsider your position and the committee of the whole, House stage, and the third reading. Mr Speaker, this bill is an important bill. As I've mentioned, it does increase the penalties for possession of objectionable material. It does fill a lacuna in the law. And I want to spend a little time, sir, talking about the presumption of innocence that it creates for repeat offenders. Because quite rightly, a little bit of concern was expressed by the Green Party, and I think they were reflecting some of the submissions to the Select Committee. I was not a member of the House, regrettably, when the Justice and Electoral Committee considered this bill, but I have read the submissions. And the Green Party's concern reflects the concern of the Legislation Advisory Committee and the Law Society. And that's fair enough. So what I did, sir, was I went and looked at the Crown Law Office advice to the Attorney-General, because members will be aware, of course, that the Attorney-General is required after the first reading of a bill, or I think it's actually after the introduction of a bill before the House, from memory, the Attorney-General is required to file a report with the House if that legislation is inconsistent with the Bill of Rights Act, unjustifiably inconsistent. And so I went and looked up the legal advice. So the first point to note, sir and Mr Hudson, is that there is in fact no Section 7 report that the Attorney-General has laid. So what that indicates is that, in his view, the bill that is before the House is consistent with the New Zealand Bill of Rights Act 1990, and that's important. Not every bill that comes before the House is, and in fact this government has introduced bills that are inconsistent with the New Zealand Bill of Rights Act, but where the government takes a different view to the view of the Attorney in his learned opinion. But I also went a little bit further than that, sir. I went and looked up the legal advice, because members will also be aware that the government waives privilege that attaches to the legal advice that goes to the Attorney-General from either the Ministry of Justice or the Crown Law Office on matters for Section 7 reports under the New Zealand Bill of Rights Act 1990. And the legal advice that came from the Crown Law Office was that the presumption of imprisonment did engage Section 9 of the Bill of Rights Act, which protects against the freedom from disproportionately severe punishment. So it engages the right, but the legal advice said that that would only be inconsistent with that right, or would only be unjustifiably inconsistent, if the effect was to require a judge to impose a sentence that is grossly disproportionate to the offending, sir. And the legal advice makes it clear that the discretion still lies with the judge. So if imprisonment is not an appropriate sentence, having regard to the particular circumstances of the case, that discretion that remains with the learned judge is enough to make sure that Section 9 of the Bill of Rights Act, which protects against, as I said, freedom from disproportionate punishment or disproportionately severe punishment, that discretion is enough to make sure that that right is not breached. So I thought that made a lot of sense, sir, and I am satisfied, although I fully recognise and understand to a certain extent the concerns expressed by my colleagues in the Green Party. I am satisfied, sir, as I think it's fair to say government members are, that there is not an unjustifiable limit on any right in the Bill of Rights Act. The other right I want to talk about, Mr. Speaker, just briefly, is Section 14. And I've had a look at the debate, and Section 14 of the New Zealand Bill of Rights Act has not really been engaged with so far. And of course that's the right to freedom of expression. Everyone has the right to freedom of expression, the freedom to seek, receive, impart information and opinions of any kind in any form. And of course this is a prima facie breach of the right to freedom of expression. And I will, sir, express a little bit of concern here, as I did on the Coroner's Amendment Bill at the latter part of last week. I will express a little bit of concern with the legal advice that went to the Attorney on this point, because the legal advice that went to the Attorney-General simply says the bill constrains the creation, possession and trafficking of objectionable material, and that is a demonstrably justified limit. That's it. That's literally the statement. It's just one sentence. There's no reasoning, there's no analysis, there's no explanation. It just asserts without evidence or without much reasoning that this is a demonstrably justified limit. And I happen to agree that this clearly is increasing the penalties, or in fact the mere existence of penalties for the trafficking of objectionable material, child exploitation material in particular. I agree that that is a demonstrably justified limit on the right to freedom of expression, because it's important that we deter the possession of this material, so that we deter the creation of the material, so that we deter the exploitation of children and others that go into the creation of this material, and we stop the re-victimisation that occurs when this material is in the public domain. But I think it would have been good to see some more explanation and more analysis within the legal advice. Sir, this is an important bill. As I mentioned at the outset of my speech, child exploitation is an abhorrent crime, and other members have mentioned this as well. It is a problem that there is some evidence of it is getting worse. Sir, I'm informed that 200 new images are put into circulation every day onto the internet. That is a shocking number, and this is clearly a global problem, but it's a problem that New Zealand can have some impact on by a bill such as this, which increases those penalties, fills a gap in the law, sir, and makes sure that the New Zealand legal system keeps up with technology that is, of course, increasing apace. I have to say, sir, it's a good bill. It's just regrettable that a party that voted for it at first reading for very good reasons is not prepared to recognise that it remains a good bill and will continue to vote for it.